Hello, so this is an update about the council tax High Court case. We've not had one for a while because we've been ignored. We did manage to, and when I say ignored, I mean that in a literal sense. I don't just mean not responding. We've actually sent a lot of emails asking for updates, and we just never got any replies. Made a complaint to the Judicial Conduct Office about being ignored. That was ignored. So I'm not exaggerating saying when we didn't get any response. So we got the hearing, as many people know, a lot of people attended online and in person, and I'm just giving a brief overview of what was actually said, so people can see what's happening next. So number one, the claim proceeds as part A claim. That's pretty self-explanatory. Number two, so this is an interesting one. They've refused us to make an argument, right? And here's the thing is they've said they refuse us permission, right? Well, we don't need permission, right? Because what happened was our statement of case, ground one was Article 8. Yeah. We're basically saying that because you don't get any court order, you don't get any warrant, there's just no safeguards. You have to rely on a council's hearsay. Council can say you owe them 20 grand, or you can owe them a grand or 500 quid. Whatever the council say, you have to take their word for it. That's the enforcement system that we operate under. It's all assumptions, yeah. And those assumptions that they're saying this was said, that was said in court as an order are then given to enforcement agents, and the enforcement agents take the council's word for it. So what we're saying as part of one of our grounds, well, that's incompatible with the safeguards obligation in Article 8, right? And there's I'm not going to go into all that now because it's quite a technical argument, but that's part of our pleaded case. And this is a statement of case. And you can see, from paragraph 17 onwards, we pleaded Article 8. So it was in our statement of case. It was already pleaded. We don't need permission to replead it, right? So what happened was the government responded to this argument, and they said, well, they don't, basically, they don't need to give any safeguards, right? Because the requirement for a written form of a liability order was abolished, right? They didn't say the prescribed format was removed, which it was, but they're saying the requirement was abolished, right? So what they're saying is because of this regulation, there's no requirement for any judicial safeguards anymore, right? So that's what. So then we replied, because when you make a claim, the defendant makes a defense, and the claimant gets a right to reply to the defense. This isn't any extra thing we need permission for. Whether it's a Part 7 claim or a Part 8 claim, you don't need permission to reply to a defense. You get an automatic reply at statute to reply. So our reply to this, paragraph 7, was, well, Regulation 3 of these regulations are unlawful, and they're unlawful because they've been made ultra vires and they're incompatible with Article 8, which is our pleaded case, right? So we're only giving a reply. We're not changing our statement of case. We're not asking for amendments, and we're not asking for permission for anything. We're just making a simple reply to their defense. And the court's like, oh, no, you can't argue that. Well, hold on a minute here. If we can't argue that, then we're prohibited from validating their defense. We just have to accept it, and that's not fair because we don't get to challenge their defense. If they want to rely on a law, right, we can challenge that. Now, if they hadn't pleaded this, it'd be different. But because they've pleaded it, our right of reply was that it's incompatible with our statement of case, Article 8, in ultra vires. But the reason why they don't want us to argue that is because they can't give a justification as to why this law came about. Because when you they can't just make laws for no reason. They have to give an objective. It has to serve a public interest purpose. And what our argument is, it doesn't serve any purpose and is actually contrary to Article 8 of the requirement for safeguards. So they've prohibited us from that, but they've not given any reasons. They just said refuse permission. We never asked for permission. So that was the first one. Is that we're appealing that, by the way. whether the appeal goes anywhere or not, but we're making it on a public record that we've challenged the fact that they're saying we're not allowed permission when we never asked for permission. It was just a standard right of reply. Uh, the second one, so they didn't file their acknowledgement in service of time, right? It was over a month late. They had zero justification for it. In their application, it said that was because the claim was academic, but yet when they made their acknowledgement of service, they've not only accepted it's not academic, but they said that this is of a public interest concern and it needs to be addressed. So that means that their original reason is completely erroneous. So they had no justification for not complying with the civil procedure rules. And then when I submitted at court that, well, hold on a minute here, we sent in the statement case in July in the pre-action protocol, and then they didn't reply until October. So they had months. And their barrister's defense was, oh, well, the Home Secretary, who it was, never sent it to the lawyers. Well, that's their own fault. You know, I submit that they're author of their own misfortune. If they've delayed it for months, they've got no one to blame but themselves. And they've just said, okay, well, it doesn't matter. If the government are breaking this court rules, it doesn't matter, right? And so normally you get sanctions for breaking court rules, and they broke them twice. We didn't ask them to be debarred from court. We just said that we wanted a finding that they've been unreasonable. And it wasn't unfair for us to say that if the government are not complying with court rules, that that's unreasonable. And to not comply for months is unreasonable. You've got standards, and the court expects even litigants in person to comply with standards. But if the government itself can't comply with standards, that's unreasonable. But the court thought, no, it's fine. And you notice they didn't give any justification as to why they've granted permission without making a finding that they've been unreasonable. The next one was adding Ministry of Housing, Communities, Local Government as a party. Now, we applied to make them a party for two reasons. The first reason is they've been discussing in private, the government, the Ministry of Justice with the Community Service, how to evidence authority to enter people's private premises. Well, that's one of the biggest kings in the case. It's all about what's the authority to enter people's premises. So they are directly involved because they're trying to discuss to issue guidance to all councils and all enforcements online. So they're directly involved, right? So this is one reason why we added him. And the second reason why we added him is in their defense, remember, they're relying on this law. Well, who made that law? It wasn't the Ministry of Justice, it was the Ministry of Housing Communities Department. So if they're relying on a law that they made and they're discussing it in private to issue guidance, they're directly involved. And yet the court has said, no, they're not going to be a party. But they contradicted themselves because they want here, they want CIVA and IRV to be well, they tried making them be a party, but we objected. But they've asked them to provide position statements and evidence. Well, why are these two authorities providing evidence, but yet the Ministry of Housing Communities are not when we've applied for them, when the Ministry of Housing Communities are directly involved? Because they don't want to justify why they made this law. And the court's helping facilitating them remain silent. The next one is we refuse to rely on audio and video evidence regarding the issue in dispute. I'm going to come back to this because I'm going to finish on this one. This is a very important one. I'll come back to number 7 in a minute, yeah? The trial is going to be 2 days. So this means that the case now is going to have 4 days of the High Court's hearing because the case management was a day, but they had they for some strange reason, which I've asked for, they gave the court a day's reading time, right? Now in a case management, you don't have a 2-day hearing for a case management, yeah? But they set 2 days for a case management, allowing the judge to read it for a day in advance, right? And then on the day, I asked them if they'd read a certain document regarding paragraph 14, right? Because they're trying to strip away our right for consent. You can only enter people's houses under paragraph 14 of Schedule 12 or paragraph 15. Paragraph 15 is a warrant. Paragraph 14 is consent. And I give many documents to show that for the last 400 years they needed consent, and paragraph 14, it requires consent. And ridiculously, despite them having a full day to read the papers, they didn't read the most important document, which clearly says paragraph 14 requires consent. Right. So I don't believe the High Court didn't read it. They just didn't want to answer my question. Did you read this document? And they said no. You didn't. You had a day to read the case before the hearing, a full day, and you didn't read the most important document that clearly says in black and white, paragraph 14 requires consent of the occupier to enter their premises. So I don't believe the High Court judge didn't read the most important document when they had a full day's allocation before the hearing to read the documents. So anyway, without getting brought up at the trial, but it's going to be a 2-day trial. Here's another unfairness thing. They tried forcing me to give a skeleton to the defendant 7 days in advance. Right? Then I argued, well, hold on a minute here. Skeleton's arguments are exchanged 3 days before. I said, if you want the skeleton more time, I'm willing to provide it to the court more than 3 days, even though it's standard practice to do it 3 days. But why should the defendant get the benefit of having our skeleton in advance? That's unfair. So then the court backtracked and said, okay, you exchange it at the same time. So the court was trying to unfairly give the defendant, the government, an advantage of reading our case in advance before we read their case. And it was only because I argued that's not just unfair, but that's against the standard practice that the court backtracked and said, okay, exchange it at the same time. Now, I want to get on to the last bit. We'll go back to paragraph 7. Now, this is a Part 8 claim. Now, there's been some erroneous comments online saying, well, you don't have evidence in Part 8. And that's wrong. You do have evidence in both Part 8 and Part 7 claims. What you're not allowed is disputed evidence, right? Because Part 7, you don't cross-examine people, so you can't test the truthfulness of evidence. So that's why you can't submit disputed evidence, because you don't get to test it. But you can submit evidence that's not disputed. Now, the evidence we're supplying is not disputed. It's video evidence of the enforcement agents. And it's very relative, because we're talking about where does the power come from to enter people's houses. And for the court to understand the gravity of this situation, they need practical examples of what is happening. The evidence that we're supplying, I'm going to show you this evidence in a minute, right? The evidence that we're supplying to show a practical example of the situation isn't disputed evidence. It's relative and undisputed, so it should be admitted. But they've refused it, right? They don't, and you can make your own mind up if you should be addressing this, because it's serious and it shows the gravity of the extent of the problem. But here's a contradiction. We're not allowed to supply relative evidence that's undisputed, but yet they've allowed IRV and CIVA, who are not related to the, well, they are related, but they're not as related as the Ministry of Housing Communities Department, right, to give evidence. So they can give evidence, but we can't, right? And one thing I've missed out, sorry, is that they refuse, number 6, the disclosure of correspondence between the defendant and Ministry of Justice. Well, this was the correspondence, but if you look, I've requested it in a Freedom of Information request. They confirm they've got the information, but they're withholding it because it's a safe space, right? They don't want to release damning evidence of what they're discussing in private about this claim. So they're more related than the IRV and the CIVA. And the court have refused this, right? Safe space. But this information is directly related to the issue in dispute. So he can't say it's not related, but yet when we requested it, the judge tried saying to the barrister, well, is it not related? And the barrister never said that. And that's not the submission the barrister made. The barrister said, oh, well, it could attract privilege. But then the barrister admitted she'd never seen the correspondence. So if she's never seen it, she doesn't know if it does have privilege or it does not. She doesn't know either way. But she didn't say it wasn't relative, and you can't say it's not relative because it's exactly under paragraph 26 that the issue is in dispute. So there was no reason whatsoever for the judge to refuse this disclosure, because no grounds for privilege were established, and you can't there's no reason to say it wasn't relative. In the barrister didn't even say that. They just point blank refused it because they don't want to release this private information that they're discussing in private about the issue in dispute, which shows that they are more connected than the IRRV and the CIVA. Yeah, but they just don't want to have to justify themselves in court for the guidance that they're saying that they're going to issue. And why did they make this law? They don't want to be held accountable. So that's why the judge refused this, so they don't have to provide any answers. Here's another thing that shows bias. The defendant shall be referred to as the Secretary of State. Now, they lost this point, right? Even by concession, right? So their argument at first, which they've been arguing for almost 2 years, was that their authority they're relying on is the Carl Turner principle. But the Carl Turner principle is just about delegation of powers for a minister. It's nothing to do with the name of the party. Whereas our authority was digital marketplace, right? And look at what the name, Ministry of Justice. Now, this case was a Part 8 claim. Our claim is the Part 8 claim. This case was about Schedule 12. Our case is Schedule 12. This case was about a declaration order. We are asking for a declaration order. So not only is this identical match, right? But in this case, Ministry of Justice were not a party. They applied voluntarily to becoming in a party. When they made an application to be a party voluntarily, they made the application in the name of the Ministry of Justice, being a neutral party, not a defendant or a claimant. So they've come in under the name of Ministry of Justice, not under the ministry, under the Secretary of State, yeah? And when we were arguing in court, the barrister conceded, we were right, we've supplied the correct authority. So not only did we have the authority, but their barrister admitted we were right, and yet they still changed the name. So why did the court do this when they had, and by the way, the court gave no reasons why they changed it, which is contrary to the case of Flannery and Flannery versus Halifax estate agent. You have to give reasons for your decision. The court gave no reasons. So why did the court allow this? Well, it's simple, right? The Secretary of State changes hands very regularly. When we first issued the claim, it was Shabona, right? Now it's David Lammy. By the time the case is heard, it'll be somebody else. So, it just gets brushed off with another person, another actor, but the Ministry of Justice stays the same. So it's all about saving the reputation of the Ministry of Justice. We won the argument in court, and we had the right authority. So the last thing I want to touch on is this here, the evidence, right? So they're allowed to supply evidence by CIVA and IRV, but we're not. But yet the evidence I'm going to show you now is directly related and undisputed, that's a very important fact, undisputed, about authority to enter people's houses. Now, when I show you this evidence, which has now been prohibited, the court has stopped us from using this evidence, right, to show the case. We're not asking them to make a deliberation on if the enforcement agents are at fault or which party is wrong. We're just showing them examples of the situation in action so they can understand the gravity. So because they need to know a basis of how bad the situation is. Yeah, if it's trivial, it's not. So this is what they've prohibited. Now, when you watch this evidence, I'm giving you snippets of different people's positions, their houses across the country. I want you to bear in mind two things. First thing is the discrepancy. You get some enforcement agents saying, we have a warrant. Other enforcement agents saying, you don't need a warrant. Other enforcement agents saying, we've got a liability order, but you need to make an application to see it. Other agents saying there's no such thing as a physical liability order. You could just see walking contradictions left, right, and centre throughout these pieces of evidence. The second thing I want you to bear in mind when you're watching the evidence is that this isn't just about the collection of council tax, right? This is about safeguards. You will see, right, that some people in this video, right, firstly, they didn't owe the debt. It was a wrong address. wrong debtor. So you've got even a woman ringing 999 for help. You've got two different people ringing 999 for help because they don't owe the council tax. They've got the wrong person. So these people are forcefully in their houses looking for the wrong person in the wrong house, right? The second thing is some of these people in these videos are disabled, right? You can't make enforcement visits like this on disabled people. They're exempt, and yet they're going in willy-nilly with no paperwork. So this is the thing you need to understand. It's not just about collecting revenue. It's about there's no accountability and no safeguards for people who are exempt or people who have got the wrong address. Yeah. So this is the evidence that has been prohibited from us using it at the up and coming 2-day trial.
Right, okay. The last time you spoke to the office was on the 23rd of April, yeah?
Yeah, yeah. I asked them how they proposed that they were going to enter the premises. So they've sent me more emails again to say that you're going to come round here and remove goods. So I just wanted to ask you which piece of legislation you was going to use to force entry.
All right, I think, yeah, last time I spoke to you, as I said before, from what I'm aware of, there's no physical form of the copy. It's just a court ordered.
Yeah.
It's just it's a court order that we get when instructed to collect. But like, there's no physical copy.
So there's no physical copy of it.
No.
What? And you're just when you get you just get told to come in and enter that property.
Well, it's a court order, but they don't give you a physical copy of it. They don't give you a physical copy of the court order. But it is court ordered, and if it was to go to court, it would be told there that it's been court ordered.
Yeah.
That's as far as I'm aware. There's no physical copy or no piece of paper that I can physically show you to say.
So
Yeah, this is.
your office will just tell you you've got it, and then you'll have to come round and just enter the
So
property.
they'll have to give you a number of notices first before it gets to that stage, which they have done, giving you
Yep.
notices, and you've been in contact back and forth with us.
Yep.
So you know, if they was to give the order to come and remove goods, that's what we would have to do, to come and
Right.
force
Okay.
entry in.
And do you know under what legislation that you would be using to force entry under?
I believe it is in the Taken Control of Goods Act 2014.
Right.
It will
Okay.
be, I think, paragraph 12 or something like that. I think it'll be.
So
I don't know off
paragraph
the top of my
12,
head.
taking control of Goods Act 2014.
Yeah,
Yeah. Okay.
I can handbook somewhere.
Yeah. It's only I've asked them to provide it. I mean, you're saying they haven't got this documentation to view, so there's no physical
No,
copy of
yeah, as
company.
far as I'm aware, there's no physical copy of it.
So you, as far as you're aware, there is a court order already in place. You to come
Yeah,
in. Right. Okay. Well, and so now you can just come round and just
when
force
they
entry.
allocate, I mean, this is the guys that I work with. We're not unreasonable. You know, we wouldn't just go there and force entry out of nowhere. We'd try and talk to you first, you know, and try and
Yeah.
resolve the matter first. But you know, if we're ordered to force entry to collect goods to make up the debt, then that's what we have to do.
Right. So does that involve smashing my door down and that, or you
I,
just use
I,
locksmiths?
you would probably use a locksmith.
Right. Okay. Well, and if I wasn't at home, so you'd be able to come in here if I was out and that.
Yeah.
All right.
Hello?
Hello, I've got a missed call from you.
Alright, yeah, just 1 second.
Asking.
It's Mr. Waller.
Mr. What, sorry?
Mr. Waller, W-A-L-L-E-R.
Right, okay, who's that?
I'm an enforcement officer with JBW on behalf of Bar Unfairness Council and Her Majesty's Court.
Okay.
It's in relation to your outstanding council tax.
Okay, what are you ringing me for?
What am I ringing you for?
Yeah.
Because a warrant's been issued, Miss Devlin, for enforcement against you under the property for non-payment of council tax. Just
Right.
on our way across there now. You're aware of the situation?
Are you aware of the situation that I've actually called your office explaining that I'm a vulnerable household and that I've removed your implied right of access?
You what, sorry?
That I'm a vulnerable person. I've actually spoke to your office and explained that twice now, that I'm classed as a vulnerable person and that I've removed your implied right of access.
You can't remove an implied right of access when a court warrant exists.
Sorry?
The judge or magistrate at the Majesty's Court petition a warrant for the council tax. You don't have the power to remove an implied right of access when a warrant is issued by the court. That's just general law, unfortunately. It's a little gibberish. Anyway, you've never provided any proof of any vulnerability you were requested to. You've not supplied that.
Who's requesting me to supply that? I've rang you up, your office have explained that before.
Explain what?
Explains that I'm a vulnerable household. Listen, so you're going to attend my property to remove goods, is that what you're telling me?
That's correct. And to carry out enforcement against you for non-payment.
Okay.
Council taxes are sensitive. So we're on our way now.
Right, so what are you going to, what are you going to do if I don't open the door? How are you going to get in?
Well, it's quite simple. If you don't open the door, once we're in attendance at the property, because a warrant exists for enforcement of the premises issued by Her Majesty's Court,
Right.
And you're now on notice that that warrant is due for enforcement this morning. If we're refused or denied access to the property or the goods within, Bar Unfairness Council will right to apply to the court immediately for a warrant of entry, will be required to remain on site in attendance at the property while the application is processed. And if it's granted successfully by Her Majesty's Courts, the court will then appoint a locksmith to attend the premises, and you could face locksmith's charges as well as £110 if goods are removed, £15 in the storage plus VAT for a minimum of 7 days, and auctioneer's fees. Okay? Able to make the payment yourself. We are authorised to accept third-party payments if somebody's willing or able to clear the balance on your behalf. But again, that would need to be on a credit card or debit card before we arrive at the property. Once we're in attendance at the property, the additional charges may be added, and that cannot affect that, and that cannot adjust that. Okay?
Well, not really, I'm not actually at the property at the moment anyway.
You don't need to be there. That's why the court issued a warrant. Non-payment of council tax is an offence.
Oh no, I understand. I understand
it's an
that.
offence for which the court has now issued a warrant against it. Okay, right. So we're on our way. I'll be with you very shortly, and we'll deal with it from there. Okay. Thanks for calling back.
Hello, right.
Enforcement agent there. Yeah. Who's going my ID again?
Can I see your warrant, please? Yeah. Can I see your warrant?
Just am I speaking to Amanda?
Can I see your warrant, please?
Warrant?
Warrant, yeah.
Well, warrant?
You should have a warrant.
For what?
Because you're an enforcement agent, you should have a warrant.
Yeah, I don't. A warrant for what?
It's got to be signed by a judge with a wetting signature. You've got to have a warrant.
Do I?
Yes.
No.
Yes, you do.
It's not a warrant.
It's not a
the
warrant.
Magistrates Court liability.
Right,
Order.
then, yeah.
Let's
so
get
I
it
need
right
that,
before you start saying things, okay? To get your facts right.
Okay.
But no, it's usually filming this, okay?
Yeah.
But we're here to enforce a Magistrates Court liability order.
Right, well, you need to give me proof.
No.
But you need a warrant.
Magistrates Court liability
Right,
order.
well, it's got to be signed by a judge, or you can't enforce nothing.
You're wrong.
No, I'm not wrong, actually. I've researched into this.
And you've got
I've
your
researched
facts
into
wrong.
it. No, I haven't got my facts wrong at all. You just woke me up off a night shift.
That's fine.
It's not fine. I just been woke up off a night shift.
That's fine.
And you got no warrant, you got nothing.
Magistrates Court liability
Whatever,
order.
you haven't even got that though, have you?
Well, you know, with respect.
Well, if you call back next time, I want that, please.
You can apply for it.
No,
But
you got to bring it with you.
If we have to call back next time.
Yes, okay.
We will enforce the court order.
Well, you bring proof with you, please.
You don't need to.
Yes, you do. I know my law.
Right, so you've been notified of my disability.
No,
Newlyn have been notified of my disability.
Right, okay.
You walked into
disabled,
this.
sir?
It doesn't
Is your
matter.
wife
You
disabled?
walked into this house.
Right.
Yeah, you just walked straight in.
Is your disability
You
a
do
reason
not
why
have
you
a
do
court
not...
order.
Yes, I do, sir.
No, you don't.
Yes, I do.
No, you don't. You have a
Perfect
debt
legal
collector.
right to come into this property.
Right, which court has issued that?
They've issued me my bailiff certificate.
Which court
Yeah, East
has
Riding
issued?
Council
No,
and
which
Northampton
court? Northampton Court.
That's correct, sir.
Right.
Northampton.
Right,
yeah.
so...
Yes. So,
Okay,
so
show
you're
me the
still
court
in,
order.
So that's
Show
it,
me
sir.
the court order then.
Sir. Sir.
You're a debt collector.
No, I'm a bailiff, sir. I'm an enforcement
You're a debt
agent.
collector.
Bailiff, sir. That camera is going to do you no good. We have a camera here, and if you want to request the footage, you can have it. I can smile for you all day. It's all right. It's
Don't
just
matter.
wasting your battery.
Don't matter, mate.
Yeah, I'm not your mate, am I?
No, you're not.
No. So if you address me as Mr. Aspinall, and I'll address you as Sir. I'll move on from there.
Newlyn and the council have been notified of my vulnerability.
Yeah, but
and my
vulnerability doesn't mean you don't have to pay your debt, sir.
So you're saying that you can walk and get out the house?
I'm saying I can walk in under
No, you
open
can't.
entry.
Right,
Yes, I
you
can.
show me the actual court order. That is not a court order. That is
It's
a
a
debt
liability
collection.
order.
No, it isn't. Show me the court.
It's liability
If
order.
I ring the court now...
It's liability order, sir.
No,
So you're embarrassing yourself.
no, I'm not.
You are, sir.
Right,
Yeah. Okay, we can do this all day.
yeah.
Or I can just carry on.
You
doing my
have
job,
been-
Or you can explain to me why you haven't made a payment.
Because-
And you are...
You have been notified,
No,
and
no, no, am I
Newlyn
right
and
or
the
am I wrong,
council
sir?
have been notified
So you
that
show
I am
vulnerable.
registered disabled.
Right. I've not been notified. Next
Yes, you have. Newlyn has been notified in writing, along with
Sir.
the council.
No.
They've
Need
sent
proof,
by
sir.
recorded delivery.
So, well,
You're
we
not
need
doing
proof,
anything
sir.
while you're in this house.
We need proof.
So, out you get. Hold on. I should
gonna
stream.
happen, sir.
I need to stream this, don't I? Because that's what they told me to do.
The court order.
Get the police slowly, yeah.
Okay.
I told you.
Get out the house.
No, we're in the house now.
We're in the house lawfully. It's called a
No,
peaceful
you're
entry.
not.
It's called a peaceful entry.
No,
That's
it's
what
not.
called.
You're in the wrong house. Now, I'm telling you now.
Okay,
Well, can we see some ID then, please?
No, I'm not showing you. I don't need to do.
Well, at the moment, I believe you're Jamie Patterson. I don't know if you're different, do I?
That's it. Hang on. Hello? Yeah, have the police, please. Yeah. Make sure you got one. Stand back a bit more, Tony. Yeah, can I have the police, please? I've got two blokes here. I've already done the barged in. I've tried to push them out. They say they can
Come on
do
in, mate.
things.
Put your camera up, please.
They're after the Jamie
It's on,
Patterson.
yeah.
I'm not the Jamie Patterson. I've got them on video. The short one's quite aggressive, yeah. No, they're enforcement officers, private debt collectors. They're not bailiffs. They haven't got the bailiff out, the private debt collectors, they've got no access
We're
in the house.
certificated enforcement agents, sir.
They've got no warrant
Okay,
of
we're going to
control,
have a
an
look
expert in
around
council
the
tax.
So we're going to...
Get your hands off me! Now, just hit me now! Get back, you get round someone round quick. PL 13 1QW.
Get your hands off me.
Sir, listen, calm down.
Get your hands off of me.
Calm down. Sir, calm down. Stop it. Stop. Listen, hands off.
You fucking...
Stop.
Right. You get your hands off of me. Right. I'm not going to be assaulted here. Right, have you finished? Have you finished?
Listen.
Have you finished?
Stop it.
Right. Well, get your hands off me and stand back. I'm not going to wait to be assaulted by you.
Keep on it, Tony.
I've got a fucking camera.
I'm not going to wait to be assaulted by you. Step back.
She's the
Okay, well listen, can we calm down? Let's all calm down.
Tony. Just keep
Right,
on.
get back. Step back.
I
I'm
can't
not
get
going to
away
wait to be assaulted by you. Right?
You're going to lose your job now.
Good.
Where's the video camera?
Sir, can we all calm down, please? Can we calm down?
We came here in peace.
No, you didn't. You weren't even in the house. You. What the thing are you fucking doing?
Because you attacked me.
I didn't attack you.
Attacked
You
him!
lost the job.
Right, can we all calm down now, please?
No, you're okay.
Well, can we all just calm down now, please? There's no need for
I'm not
noise.
going anywhere, sir.
Look at him. He's really
What the fuck do you think he's doing?
Listen, can we just calm down?
No, you get him out.
Well, once we've established, you're not saying... Listen, what we're trying to
I
establish
told
is...
you to go outside.
Jamie doesn't live
Don't
there.
start saying
No, he
seriously.
doesn't.
Well, I don't know you, you haven't met me,
Yeah.
we've not met before, have we? Okay.
No, you shouldn't be nuts like this. You're going to have...
Well, this is called a peaceful entry. This is...
No, it's not a peaceful entry.
Listen.
I told you to go out.
Can I...
No.
Defend myself.
You're not acting as a bailiff.
Defend!
Council tax, you've got no auto, right?
So, it's an
You haven't got
open
no
field.
auto.
So what's your name?
Out.
So what
What's
we're
your
trying to
name?
establish is
What's
you're... Well, because at the moment I don't know you're not Jamie Patterson.
Out and I'll tell you. Out and I'll
Well, no,
tell
if you show me your driving licence or
Yeah,
council tax or
please,
something like that, it will resolve the whole matter. Do you see what I'm saying?
Hello? Yeah, no, these attacked me. I nearly went unconscious. Can you get someone around quick? I tried to move out of the porch and they went for me. It's on video. No, he's aggressive and he just tried to... I just nearly got unconscious. I nearly went unconscious. It's too late. He's been in the kitchen and he's rummaging through paperwork. Okie doke. Thanks very much. Thanks. Okay, bye. You got to wait now. They said not engage with you.
Okay, well we're going
I've told you.
Get off of me, sir.
Listen.
This isn't my stuff. That's
Sir, you're not engaging with us. We're here.
out of the way.
We are here to enforce a liability
you're
order,
with
sir.
Listen.
You're at the wrong house. I'm telling you. Don't come knocking at my door.
You've just informed your name's Mr. Patterson.
Yeah.
We're looking for Jamie Patterson.
And that's all you're doing, passing with it.
But I don't know you're not. I do not know you're not Jamie Patterson.
There must be an age.
No, we don't get. So we
Right.
get a liability order issued by the courts. That's what happens.
It's not issued by the court.
Yes.
Yeah.
It's not a liability order in the court order. It's a notice. It's a statement to say that money is owed.
Sir, we don't get involved.
You've lost your job.
Well, you crack on and do what you need to do, sir. All right. The bottom line of this is you've attacked me twice. I'm going to defend myself all day long. Okay. So
You've tried to get
to
to my property, and you know that.
So it's called a peaceful entry.
It's not a peaceful entry when I didn't let you in. I can say no. You're debt collectors.
And then
you're
you attacked us.
You're not court bailiffs.
We are certificated court.
You're not for council tax.
Sir, let's wait until the police come.
Yeah.
Not a problem. We'll have a look around the house in a minute.
You won't.
Listen.
No,
Get off me again!
You've lost your job.
Sir, you keep attacking me, right? Okay,
Get out
let's
now.
seize that for the police as
Yeah,
well.
I've lost your job.
Sir, you keep attacking
No,
me.
you told me it's okay to do.
No, you keep attacking me. Get off of me now. Get off of me, sir.
Can we
Get
just
those down.
It's all recording.
Sir-
It's all recording. Can we just calm down,
You've lost
please?
your job now.
Right, okay, what we're going to do, we're going to wait for the police.
No, you give us that.
We'll be back. No,
No, you won't. I'm telling you now.
Come on, sir.
No, you can stay in.
Hey, whoa! You're not looking in a house. You're not looking in a house.
Sir, listen, we don't know who you are.
You have lost your job, but you haven't told me who you are either.
Yeah, we'll wait for the police to come.
The paper then.
No, you're getting anything. We'll wait for the police to come. Let's go.
No, let's go. You wait. Hey,
listen.
You go. No.
But you have no right to take his camera.
I'll give it to the police when they arrive.
Where are you from?
Where am I from?
Yeah.
I can show you, man. I've showed you already.
Show me your court order.
Court order?
Yeah. Show me your signed court order.
There's the...
Yeah. Let me see that again, please. I didn't see that.
I'm not...
You're not saying show me it again?
I'm not going to have you filming my identification, no, man.
I can, because it's legal.
I've showed you it twice.
I suggest you leave my property.
I'm not going to be leaving today, madam.
Right, okay. I know my legal rights. I've sent you enough information.
What information have you sent, madam?
That I'm a vulnerable
You
person.
haven't said that at all, have you?
Yeah.
I've looked on the notes and yeah.
Oh, it must be Jacob then.
Sorry?
Must be Jacob to send
You
that to.
haven't sent that to us, have you?
Well, I am, so carry on what you're doing.
Okay, well, carry on. What am I doing?
Yeah, carry on what you're doing. I'm a vulnerable adult.
Okay, so that's
Right,
what,
carry on what you're doing.
So what I suggest you do then is call our office and call the welfare team and explain the situation that
I
you're
already did that to another bloke, but he took no notice, so...
Yeah, but you've just said it's a totally different company.
No, but I did phone up and explain.
What, to Bristow and
To
Suter?
Bristow and Suter, and I've sent a
that's
thing
not
about
on the
coming
notice.
onto my property without a proper court order.
Okay, I have got a proper...
You haven't got a proper court order.
You're more than willing to call the police if you like. And
Well, call the police. You call the police.
You're the one that wants to call the
You
police.
call the police, mate.
But anyway, as
you
you
haven't
said,
got a court order.
I have got a court order.
And you're harassing a vulnerable adult with a vulnerable child in the house.
So now-
Go away.
Let me talk.
Go away.
Okay.
You've got no legal right. Get off my property. Right off my
That is
property.
that is your boundary, isn't it?
No, it's not actually. It's past this.
That's your boundary.
It's
That's
past
your
this,
gate.
actually.
No, that's your neighbour's.
Out you go.
No, I'm out.
Exactly. You're not even allowed on my property,
I
see?
on your property.
No, you're not, because I know the law.
Because you said you're vulnerable, that's why I've left.
Yeah, good.
So what I suggest you do
See
is
ya.
give the company a call tomorrow. And
What you
explain
do
the
is horrible. I know you've got a mortgage to pay and bills and that, but what you're doing is horrible, mate. Go away and harass someone else.
I have to pay my council tax.
Whatever. We all pay our council tax, darling.
Madam, that's it.
Fuck off.
Lovely.
Harassing people.
Perfect language.
It's English language.
Is it?
Yeah. Fuck off.
Is that English language?
Yep, mate.
Yeah?
Yeah. Don't come to my house again.
Madam, if you like to send that information...
Don't come to my house again.
Madam, if you don't send that information over there, they will be returning, okay?
Ta-da.
See ya.
That's bollocks. You know that's bollocks. No way. No, it's a load of shit. The law doesn't change. You guys are changing it. Doesn't mean the law has changed. Law has not changed. Law has been the same. Absolutely no chance. Mate, get a court order and come back. You haven't got a court order. You're just playing this game. I'm going to honestly. What's your name?
It's Mr. Howarth, sir.
Mr. Howarth. What's your anything else? Any other ID?
I've got my ID. That's my ID, sir.
And Howarth, yeah. And I'm going to sue your ass. I promise you.
That's my certificate as well.
That's fine. It doesn't make any difference. There's no court order. You shouldn't be here. And I've already asked you lot. Provide me the court order. Take it with you. Magistrate's liability order, where? What? Are you saying to me this is magistrate's liability order just because of that? It's a lot of shit. Yeah. It's not worth the paper it's written on. Get the fuck out of my shop. Honestly, you're taking the piss. You know it as well.
Well, the bill needs to pay, doesn't it, sir? You know
it does not. It's got nothing. My bills do not concern you whatsoever.
No.
It's between me and the council. The council bollocks to you. Get the fuck out of my shop before I start. I don't give a shit. You shouldn't be here. I couldn't give a fuck. You shouldn't be here. Fuck you. Okay? Yeah, you shouldn't be here. I've said it nicely to you, but you're not listening. Show me the court order. Show me the court order, and I'll happily oblige. But you haven't. No enforcement order has been. What is it? I'll ring the court to ask them where is the court order. The council is not the court.
No, I'm just getting on with taking control.
Get the fuck out of here. You touch anything and I'll fucking kick your ass.
Oh, that's fine, sir.
Give me that bar, papa. I'm going to kick the fuck out of this guy. Give me that fucking bar. Go on. What did you want? Get the fuck out of my shop now. Go on, fuck off. There's a door. Take your piece of shit with you. Go on, get the fuck out of my shop!
Don't threaten me, sir. That's what I mean.
So I'll open that door. Fuck you, Stan.
Don't talk me out, sir. Don't
Get out of my shop. Get out of my shop. Get out of my fucking shop. Get out of my shop. Get the fuck out of my shop. Now! And do not come back.